Good evening, ladies and gentlemen. Good evening to our honorable judge.
Good evening.
Tonight, we are grateful and happy to have with us our celebrity guest to discuss legal topics in criminal procedures. We'd like to introduce the member of the group. First, with us, Derek Ramsey, or Mr. Shelo Bonachita.
Good evening, classmates and judge.
We have Jericho Rosales, Justino Vicariato.
Good evening.
And a handsome man, the hottest person in the earth this time, Gerald Anderson. Jason Campbell.
Good evening, viewers.
And yours truly,
Good evening, good evening.
broken-hearted person, John Luz. Tonight, we will discuss some important matters regarding new trial up to cybercrime law. Our first speaker will answer some questions to be asked by the following members. We have Mr. Gerald Anderson. As to start our discussion, I would like to ask a question regarding what is the purpose of a new trial in criminal case?
The purpose of new trial in criminal case is to temper the severity of a judgment or prevent the failure of justice.
Okay. My second question, Mr. Loverboy, Mr. Gerald Anderson, sir, do you still remember the grounds for new trial?
Yes, of course. The court shall grant a new trial on any of the following grounds. First, errors of law or irregularities. That errors of law or irregularities which are prejudicial to the substantial rights of the accused have been committed during the trial. The second ground is the newly discovered evidence. That new and material evidence has been discovered which the accused could not, with reasonable diligence, have discovered and produced at the trial, and which, if not introduced, admitted, would probably change the judgment.
Okay. Thank you for
Those
that.
two are the grounds wherein the court shall grant the new trial.
Okay. Thank you for that very wonderful explanation, Paniero Gerald Anderson. So,
You're welcome.
when may
You're welcome.
a motion for reconsideration in a criminal case be filed?
The motion for reconsideration may be filed at any time before a judgment of conviction becomes final.
Oh, I see. So, Mr. Loverboy, Mr. Gerald Anderson,
Yes.
what are the grounds for
Yes.
reconsideration in criminal cases?
In criminal cases, the grounds for reconsideration is where the court shall grant such reconsideration on the grounds of error of law or fact in the judgment, which requires no further proceedings.
Okay, last question. What are the effects of granting the new trial or reconsideration?
The effects of granting a new trial or reconsideration are the following. First, when a new trial is granted on the ground of errors of law or irregularities committed during the trial, all the proceedings and evidence affected thereby shall be set aside and taken anew. The court may, in the interest of justice, allow the introduction of additional evidence. The second effect will be when a new trial is granted on the ground of newly discovered evidence, the evidence already adduced shall stand and the newly discovered and such evidence, other evidence as the court may, in the interest of justice, allowed to be introduced shall be taken and considered together with the evidence already in the record. And the third ground will be, well, in all cases, when the court grants new trial or reconsideration, the original judgment shall be set aside or vacated, and a new judgment rendered accordingly. Those are the effects of new trial and reconsideration in criminal cases.
Oh, okay. Thank you for that, Panyero, Loverboy, Gerald, and
You're welcome.
so
I
now,
guess you don't have any more questions.
yes, thank you for that.
None so far, Mr. Loverboy, Gerald Anderson. Thank you for the enlightenment.
Thank you. So,
Thank you for the
You are
wisdom that
very
you have.
much welcome.
I may now ask, okay. Now I may ask Panyero Derek Ramsey, Shalom Bodachita. Panyero, what is an appeal?
That's a good question, Paniero. Jericho Rosales, the Mr. Guapo of Liceo de Cagayan University. Appeal is a proceeding for review. Take note, Paniero, it is for review, by which the whole case is transferred to the higher court for a final determination. The right to appeal is a mere statutory privilege. Only final judgments and orders are appealable.
Now it's time to ask you, Panyero Derek Ramsey. Can you hear me, Panyero?
Yes, Paniero.
Now the question will be, may the prosecution appeal a judgment of acquittal?
Paniero Jericho Rosales.
Oh,
Gerald Anderson. Thank you for that wonderful question again, Mr. Loverboy, Gerald Anderson. General rule, no, the accused would be subjected to double jeopardy. But there is an exception. If the dismissal is made upon motion or with the express consent of the accused. There's also an exception to the exception. One is insufficiency of the prosecution evidence, or B, violation of the accused's right to a speedy trial. Another, if the dismissal is not an acquittal or based upon consideration of the evidence on merits. And three, if the question is purely legal, so that should the dismissal be found incorrect, the case shall be remanded to further proceedings to determine the guilt or innocence of the accused. I hope I answer your question, Mr. Loverboy, Gerald Anderson.
Okay,
Yes, you did, Panyero Derek Ramsey. Thank you.
Mr. Loverboy, Derek Ramsey, where to file an appeal?
That's a wonderful question. My good friend, Paniero, the retired playboy, John Lloyd Cruz. An appeal shall be taken before the RTC in cases decided by Municipal Trial Court, Metropolitan Trial Court, or Municipal Circuit Trial Court. An appeal could also be filed in Court of Appeals or to the Supreme Court in the proper cases provided by law, or in cases decided by the Regional Trial Court or RTC. Supreme Court also in cases decided by the Court of Appeals. Supreme Court in cases decided by City in Bank or Court of Tax Appeal. And Supreme Court in cases decided by the Sandigan Bayan. That's all, Paniro. That's the where to file an appeal, Mr. Retired Playboy.
Oh, okay. Thank you for that,
Very
Panyero
good.
Derek Ramsey. Well, in instances, Panyero, what is the effect of the appeal against several accused?
Yes, thank you, Mr. Guapo of Liceo de Cagayan University. Appeal taken by any of the several accused shall have the following effects. One, remember this, Mr. Guapo, that it shall not affect those who did not appeal, except insofar as the judgment of the appellate court is favorable and applicable to the latter. 2. The appeal of the offended party from the civil aspect shall not affect the criminal aspect of the judgment or order appealed from. And lastly, Paniero, the important, upon perfection of the appeal, the execution of the judgment or final order appealed from shall be stayed as the appealing party. That's the three instances, Paniero, that the appeal against several accused, the effect of their appeal is.
Now, the last question for you, Idol Derek Ramsey, will be this. What are the grounds on the dismissal of an appeal?
Thank you, my good friend Paniero. Gerald Anderson, I know you're busy with who's the girl right now? Barito?
Barreto.
Anyway, just regards me to your good friend Barito there. Claudine Barito or Gritzy Barito? Anyway, here are the
Claudine
grounds of an appeal. I will mention few so that you will be familiar with the grounds. 1, failure of the appellant to serve and file the required number of copies of his brief of memorandum within the time provided by these rules. Number 2, appellant escapes from prison or confinement, jumps bail or flees to a foreign country during the pendency of the appeal. 3, failure of the record on appeal to show on its face that the appeal was taken within the period fixed by these rules. Number 4, Paniero, failure to file the notice of appeal or the record on appeal within the period prescribed by these rules. The 5th one, failure of the appellant to pay the docket and other lawful fees. 6, unauthorized alterations, omissions, or additions in the approved record on appeal as provided. 7, absence of specific assignment of errors in the appellant's brief or of page references to the record as required in Section 13, paragraph A, C, D, and F of Rule 44. And lastly, Paniero, failure of the appellant to take the necessary steps for the correction or completion of the record within the time limited by the court in its order. I hope I answer your question, Paniero, clearly and correctly.
Thank you very much, Idol Paniero Derek Ramsey.
Now, Paniero, it's my time to ask our good friend Paniero, the retired playboy, a very good question topic to be discussed also about search and seizure.
Go ahead.
My good Paniero, yes, are you ready, my good friend, retired playboy John Lloyd Cross, for a small question about search and seizure?
I am ready.
Yes, as we all know, Panhiro, it is high time right now because of the PDEA and PNP situation, where there is a buy bus and there is a sell bus. I want to ask you, Panhiro, the retired playboy, what is the nature of a search warrant?
Okay. A search warrant is in the nature of a criminal process, akin to a writ of discovery. It is a special and peculiar remedy, drastic in its nature, and made necessary because of a public necessity.
Oh, I
Oh,
see.
that is very clear to you, our idol, Derek Ramsey.
Thank you. That's clear enough. The retired playboy, very good Panhiro.
Oh, okay. Now it's my time to ask a question again for you, Paniero, retired playboy John Lloyd Cruz. So, in that instances, what does probable cause mean?
Well, probable cause is the existence of such facts and circumstances as would incite the belief in a reasonable mind and acting on the facts within the knowledge of the prosecutor that the person charged was guilty of the crime for which he was prosecuted.
Oh, okay. Thank you for that wonderful explanation, John Lloyd Cruz Paniero.
Welcome, Jericho. Next
Now,
question, please.
another question for you, Mr. Retired Playboy. Assuming that I want to search your house, where can I file for a search warrant? Please answer my question, Retired Playboy.
Okay. Since you want to search my house, if there are any illegal activities or any object, any court within whose territorial jurisdiction the crime was committed can be filed any of the court which has jurisdiction in the area or for compelling reasons stated in the application. Number one, if the place of the commission of the crime is known, any court within the judicial region where the crime was committed. Number two, any crime within the judicial region where the warrant shall be enforced. However, if the criminal action was already been filed, the application shall only be made in the court where the criminal action is pending. Is that clear? Am I clear to you, Panyero Giran?
Very
Yes,
clear, Panyero, Retired Playboy. Thank you so much.
my good friend, retired playboy John Lloyd Cruz, somebody texted me and want me to ask you a question. Is
Okay,
there
go ahead.
any exemption for the application of warrant, of search warrant?
Yes, there are exemptions in the application for search warrant. If a case was not yet been filed, it may be filed in a court with a territorial jurisdiction other than that where the legal articles sought to be seized are located. This is aside from the consideration that a criminal action may be filed in different venues under the rules for continuing crimes, or where the different trial courts have concurrent original jurisdiction over the same criminal offense.
Okay, I see. Thank you for a wonderful answer, Mr. Loverboy. Out, the retired playboy John Lloyd Cruz.
Mm, okay.
You're welcome.
Now,
Idol Derek.
now, Paniero John Lloyd, uh, someone also called me with regards to the time of the search warrant to be served. Since he's
Is
from
that
Osami
Ilin
City.
Adarna?
Yeah, don't want to disclose the identity of the one who texted me because he's very close to the people who were uh, 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 been a victim of such heinous crime in Osami City. So she asked me rather that on what time should a search warrant be served?
Okay. A search warrant can be served daytime unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which case a direction may be inserted that it may serve at any time of the day or night. That is under Rule 126, Section 9. A search warrant violates Rule 126, Section 9 if the time for making the search is left blank. So it must be filled in, thus enabling the officers to conduct the search in the evening of the appointed search, causing untold conveniences to the person searched. So even though there is a warrant or search warrant be served, it also advocate the privacy of the person to be searched. Where a search warrant is to be made during the nighttime, the the authority for executing the same at that time should appear in the directive on the face of the search warrant.
Oh, okay. Thank you for that explanation.
You're welcome, Pañeros.
Now, for the last speaker for tonight, Mr. Paniero Jericho Rosales. My question for you will be,
Pero,
what property may be seized?
well, in that instance, Panero, there are three subjective property that could be or may be seized. Number one, personal property subject of the offense. Number two, personal property stolen, embezzled, and other proceeds, fruits of the offense. Then number three, personal property used or intended to be used as a means of committing an offense. Well, this rule does not require that the property to be seized should be owned by the person against whom the search warrant is directed. However, it is sufficient that the person against whom the warrant is directed has control of possession of the property sought to be seized. Am I answering your question, Paniero?
Yes, Paniero, thank you very much.
Thank you.
Paniero, Mr. Guapo of Liceo University.
Thank you.
Paniero
Paniero.
Jericho Rosales. A good friend of ours, the name of Edwin Marshall, alias Daniel Padilla. I want to
Oh,
ask this question.
he's a very
What
good friend
is
of
a
mine.
plain view doctrine?
Oh, okay. Oh, Mr. Daniel Padilla, Edwin Marshall is a very good friend of mine as well. Well, the plain view doctrine, this is usually applied where a police officer is not searching for evidence against the accused, but nonetheless inadvertently comes across an incriminating object. So even if an object is in plain view, before it can be seized without a search warrant, it must be incriminating in nature. That it must be apparent. So when a police officer are on the premises pursuant to such valid consent to a search, an item falling into their plain view may properly be seized even if the item is not connected with their purpose in entering.
Wow. Thank you,
You're
Mr.
welcome.
Guapo. That's a
You're,
good question. Answer.
thank you, Derek Ramsey Paniero.
Hey, Mr. Pañero Jericho Rosales. I would like to clarify what is this stop and freeze situation?
Okay. Okay. That's a very good question, Paniero John Lloyd Cruz. This stop and frisk situation, it is where a police officer observes unusual conduct, which leads him to reasonably to conclude, in the light of his experience, that a criminal activity may be afoot, and that a person with whom he is dealing may be armed and presently dangerous. Where in this course of investigation, this behavior, he identifies himself as a police officer and makes reasonable inquiry, and where nothing in the initial stage of the encounter serves to dispel his reasonable fear for his own or other safety. When he is entitled for such protection of himself and others in the area to conduct and carefully limited search of outer clothing of such person in attempt to discover weapons which might be used to assault him. So that's in stop and frisk situation. Those were the instances. Uh, Paniero John Lloyd Cruz, Mr. Ungat.
Another question for you. I have another question for you, Paniero Jeric Rosales. What if Paniero retired playboy will be subjected to unlawful search and seizure? What are his remedies? Can you please answer that?
Well, he may be subjected to some remedies. One of which, he may file a criminal action against an officer. So a public officer or employee who procures a search warrant without just cause, he is criminally liable under Article 129. Well, the general rule is the motion must be filed before the sala of a judge who issued it. and only the court that issued the search warrant may order revocation of such search warrant or release of the thing seized. There is also an exception to that rule, where the search warrant is issued by one court and the other criminal action based on the results of the search is afterward filed in another court. The motion may be filed in either court.
Thank you very much, Panyero.
Panyero, Mr. Guapo,
Oh,
Jericho Rosales. I think this is our last question for the day. What may be raised in the motion to quash?
okay. That's a very interesting question, Paniero, Derek Ramsey. So there are two instances. Number one, existence or non-existence of probable cause at the time of the issuance of the search warrant. Then second is compliance with procedural and substantial requirements. So those are things to be raised in filing for a motion to quash.
Thank you, Panyero. Thank you.
So it's a wrap. Panieros, Derek Ramsey, Paniero, John Lloyd Cruz, and Paniero, Gerald Anderson.
Anderson.
Yours truly, Jericho Rosales, the chubby version. So thank you for this wonderful discussion we have tonight. I think it's a wrap. And
Yes, thank you very much.
say good night to our viewers in our podcast. So,
Good night and sweet nightmares, everyone.
okay. Good night to everyone. And
Good night.
Good
And
night,
thank you for
everybody.
the privilege to be with you, my Panieros.
Thank you.
Thank you.
The
Thank you.
pleasure is mine, Panieros.